Morning, everyone. My name is Sicelo Kula, and I'm one of the data protection lawyers at Michalsons. I'm joined today by our managing attorney, John Giles, and of course, my colleague, Jade Morris. And we'd like to welcome you to our webinar talking about exemptions under POPIA. Of course, the key thing there is that we are talking about POPIA. We aren't talking about exemptions from having PIA manuals under PIA. So that's one of the things that's worth getting out of the way right from the get-go. We're also not talking about prior authorizations or any of the other things that you really have to interact with the information regulator with. So we'll very much be focusing on that. Of course, we'll be making this an interactive session where we'll be talking pretty much for the first 20-25 minutes and then really opening the floor to you to ask your questions. Of course, you're welcome to ask those questions in the meantime and pop them into the chat and the Q&A box. And one of Jade's roles will be to look at those questions and collate them, identify some of the recurring questions, and then put them to John and myself. But in terms of the questions, we'd really like them to basically just be about exemptions and not talk about some of the other things really that I mentioned. And yeah.
Yes, maybe just to pick up on the PIA manual exemption, there's a lot of questions about that, and some private bodies are exempt from having a manual, but only up until the end of this year. So really from next year, everybody needs a manual, nobody is exempt. But that's not what we're talking about today, but just to mention that, but that's a different discussion. Today we're talking about an exemption from POPIA or certain conditions or sections of POPIA itself.
Yeah, definitely, John. And then just in terms of getting a better sense of who's joining us in the room, we do want to know, I mean, even if we're not ultimately seeing you, and this isn't what we're normally used to, where we're in the same room as you and we're looking you in the eye and speaking to you, we do still want to get a better sense. We're going to run a few polls just to achieve that. So one of the first polls we're going to run is just to get a sense of the type of organizations that you're representing, the people that are joining us on this webinar. You'll see that we've distinguished between, so let me just launch the poll just so that you can start voting. You'll see that we've distinguished between public bodies, private bodies, and nonprofits, which are also private bodies. But the key thing, and this will make more sense when we go through the session, is that in certain instances, for certain kind of organizations, it might be easier to get an exemption, or you might be automatically exempt because of the type of organization that you are. So in many ways, it makes sense to try and get a good understanding or a good sense of which kind of organization is on the call or is represented on this webinar.
Yes, sorry. Organizations are actually, you're a public or a private body. You have to be one of them. Public bodies would be government, municipalities would be the National Prosecuting Authority. Private bodies would be companies, CCs, trusts, sole proprietors are all examples of private bodies.
Yeah, so let me end the poll there and just have a look at the results. So I'll just share the results so you can see. Yeah, so it seems a lot of the people on the call are representing private bodies in general, and then there are a good number of people representing nonprofits and to a lesser extent representing public bodies. But at least it's a mixed audience. It's not just one and none of the others really. So I think that's good.
The bad news for the audience today is that it's generally speaking public bodies who have a better chance of being exempt rather than private bodies. So it's surprising that there's so many private bodies, but I agree, there's still a chance private bodies could be exempt. Yeah.
And then in terms of private bodies, it's usually mostly nonprofits that also have quite a good chance as well. And this, again, we'll get into this and it'll make sense why we say that. But I just want to run two other polls. This other one is just to get a sense of the size of the organization. And maybe, John, you can just talk them through that a little bit.
Yeah, it's always good to know what size you are. You know, the problem is that the impact is different based on how big you are. And 50 and 250 employees are globally seen as watershed amounts of employees, and globally, organizations under 250 employees are exempt from certain things. So it's always interesting to get an idea of what size organizations are on a call.
Yeah, definitely. Okay, look, I think, yeah, let me end the poll there.
I think what's interesting here is we've got lots of smaller organizations, and I think small organizations are probably hoping that they're exempt because they're small.
Yes.
And unfortunately, at the moment, small organizations are not exempt because they're small. For me, this is something that I'm very passionate about, and I think that the regulator needs to exempt smaller organizations. But I'm afraid you're going to be disappointed in that at the moment, nobody's exempt because they're small.
Yeah, yeah. I mean, I think it obviously gets a bit tricky when you're talking about a small organization, but the impact of POPIA on that organization isn't necessarily small because of the, let's call it, intense processing that they're doing, for lack of a better phrase. So it gets tricky, but I definitely take John's point, and I agree. Okay, I'll just run the poll about the role, your role in the organization. And then maybe you can talk us through this one as well, John.
Yeah, it's always good just to get an idea of at an individual level who's on the call, and yeah, to know who we're addressing. I'm expecting it to be many information officers and in-house legal and compliance, because typically those would be the people trying to work out whether or not you're exempt from a particular law. But yeah, if you wouldn't mind marking, that would be great.
Okay, I'll just give it a few more seconds. Most people have voted. Okay, I'll end the poll there. And then just share the results. So we've got a good number of organizational heads. We've also got a good, in fact, most of the people that are on here are information officers, which is quite interesting, with a few also identifying as data protection officers. And then we've got in-house legal. So it's, again, it's quite a mixed audience, which is never a bad thing, because ultimately, with the delegation of different duties, it gets quite interesting in an organization who is actually going to be submitting the exemption application to the regulator at the end of the day. So it makes sense why it would be different people that are on this webinar. Okay, so I think as far as polls are concerned, let's pause there and then just get into some of what we want to discuss. So I'll just share my screen. Okay. Just get into present mode. Okay, so one of the first things that I just wanted to talk about in terms of giving some context as far as exemptions are concerned. And again, this is something that seems to be at the core whenever you're talking, for example, about the grounds on which you are going to be basing your exemption application, or to determine whether maybe your exemption application is even going to succeed. And that is, we often talk during our presentations about why data protection is important. And while I won't go into everything that we'd normally talk about, the one thing I just wanted to touch on is this idea that data protection is about protecting data subjects from harm. And what you'll see when we talk more about the exemption application is that often the difference between you getting the exemption or not getting the exemption when you're applying to the regulator often comes down to how much harm you'll be causing to the data subject with your processing. Data protection laws, of course, are all about protecting data subjects from harm. So that's really one of the things that I wanted to touch on, is that often it comes down to that. And then before I get into the global view, and these two are quite closely linked, and it'll make a whole lot of sense. And that is, once we've gotten over the hurdle of whether you're exempt or not, it naturally has an impact on it relates to what the impact of POPIA has on your organization. So of course, you would have probably heard from us saying that the impact can either be low, medium, or high. And naturally, when you are exempt from having to comply with certain aspects of POPIA, it might very well affect the impact that POPIA has on your organization. And the key thing there is that this relates to your compliance strategy as well, because if the impact of POPIA has been lowered due to you being exempt from having to comply with 4 of the conditions, then certainly your compliance strategy has to change. The level of compliance that you're trying to achieve and how you're going to go about that has to change. And again, we often say that this has to be captured in a data protection policy. I don't know if you have any other thoughts, John, before I flip across. So I'll just quickly take a step back. So we often also talk about the global view, the need to take a step back and look at what laws you need to comply with, because before you can start complying, you need to actually have a good sense of what laws apply to you. So in a data protection context, especially because we're talking about exemptions and the potential non-application of the law entirely or certain aspects of it, it makes sense to look at something like this. So of course, for the purposes of this webinar, we're talking about POPIA. And one of the key questions here is, who must comply with POPIA? There is a poll that we'd like to run at this point, just to get a sense of who thinks they shouldn't comply with POPIA, because since we're talking about POPIA, if you don't believe that POPIA applies to you, then in many ways, it doesn't make sense for you to continue being on this webinar, because you've decided that POPIA doesn't apply to you.
Yes, I think that's a great point, is that, the journey of any compliance program is to start with, well, do we need to comply with this law? And there are different components to answering that question, and we'll look at this in more detail. But the first question is yeah, does the law actually apply to you? And in essence, it's 2 questions you need to ask yourself. The one is, are we domiciled in South Africa? So if you've got a company registered in South Africa, which is a PTY Limited or a non-profit company, then you are domiciled in South Africa, or you're probably domiciled in South Africa. So the first question is, are we domiciled in South Africa? The second question is, do we process in South Africa? So let's say, for example, you're a company that is based in the Netherlands, you're registered in the Netherlands, you're a tax resident in the Netherlands, you are domiciled there. But if you process in South Africa, then you need to comply with POPIA. So those are the 2 questions that you need to be asking yourself. It's a domiciled in South Africa or processing in South Africa.
So I think let me launch the poll then at that point, at this point, now that you've given that context. So if you could go ahead and just start voting.
Yeah, and I'm expecting most people to say yes. It'll be few that say no. And there are some tricky ones. The one example is it's a company registered in the Netherlands, but they're registered as a foreign entity in South Africa. The question then around domicilium becomes harder to answer. And so there probably will be a few of you who are not sure. And also around processing, for example, if you're external, but you've got one processor or operator in South Africa who processes for you in South Africa, does that then mean that you need to comply? That's another tricky one where there's sometimes some questions.
Okay, so I think let me end the poll there. Just give it a few more seconds. Most people have voted. Okay, I'll end it and share the results. And yeah, as John said, most of you do believe that you have to comply. In fact, 94%, which is quite a huge number. And then there is a small percentage that aren't sure. And then, so the other related part of this is once you get over the hurdle of you believing that, yes, you have to comply with POPIA, another related aspect of this is, okay, yes, we have to comply, but are we excluded from the application of POPIA? And while we won't be going into a lot of detail around this, I mean, one example I can give just to help it make sense is, let's say you're processing for journalistic purposes. So that would be one example of an exclusion. But I think let me just run a poll, unless, John, before I run the poll, there is further context that you'd like to give.
I think if we just go back to those questions, let's just run through those questions in a bit more detail.
Okay, sure.
So I think it's important to the process is, does POPIA apply to us, which is what we've just done. Then the question is, are we excluded? And then we get on to exemptions. So exclusions, they relate sometimes to everything that a body does, and sometimes it's just a component of what you're doing, some form of your processing activity. But Sicelo, maybe do you want to run through those questions?
Yeah, okay, sure. Do we process personal information that is not entered into a record?
Yeah, so if you're answering yes to any of these questions, then you're excluded. In other words, if you've got personal information, but it's not in a record, then POPIA doesn't apply. And I often joke with people and say to them, if you've got a massive warehouse of personal data, what you can do if you want to solve your POPIA problem is just go into the warehouse and make a big mess, because then it's just lying all over the place and then it doesn't apply, which is obviously just, it's ridiculous. But that's the point there.
Yeah. Do we process personal information in the course of purely household activities? I mean, think about paying your bills, your household bills. It would be quite crazy to expect you to have to comply with POPIA as part of doing those normal household activities. Of course, not to suggest that you would then be reckless with that information and leave it lying around in the yard or outside your yard, but certainly it would be a bit crazy to think you have to comply with POPIA as part of that. And then the third one is the information we process de-identified so that it no longer amounts to personal information? Of course, the key thing about POPIA is it applies to the processing of personal information, and personal information is information that identifies a person, a living natural person, or an existing juristic person. So if that information can't or doesn't identify such a person, then really it's not personal information, and therefore POPIA can't apply to it. It sounds simple on some level, but it can be quite tricky. And then, are we a public body that protects national security? I mean, think about the police, think about the army, for example. And then, are we a public body that prosecutes offenders? Think about the NPA, the amount of personal information that they have to process as part of that.
Yeah, I mean, imagine a scenario where you've got a suspect, and there's a public body that's prosecuting that suspect, and they're able to say, no, you're not allowed to process my personal information. It would just be ridiculous. So that's why they are excluded.
Yeah. And then, of course, I think we've probably covered the gist of it, and maybe we can run the poll. I'm also just thinking about the interest of time as well.
Perfect.
Okay, so I'll just quickly launch the poll.
I think while you're answering that, the reason we said but only some is to remember, for example, if you are a journalist, you're excluded when you're processing for journalistic purposes, but not for other things. So for example, you still got to protect your employees' personal information. It's only an exclusion relating to specific things, the function that relates to what's on that list. And there are not going to be many of you who are excluded, it would be my guess, because of the fact that most of you are private bodies. The exclusion really is for public bodies, for purely household activities, and then for journalism or artists.
Yes. Okay, I think let me end the poll there. I'll just give it a few more seconds for people to vote, but most people have voted. So let me end that and share the results. Yeah, and as you rightfully said, John, most people do believe that they're not excluded from the application of POPIA, and then others, I'm not sure, or yes, maybe, but only for some aspects of our processing, but not everything. And that makes sense to me, as you said. Okay. So I think let's get into this issue of exemptions a lot more. So really the impetus, just to give some quick context around this, the impetus for this discussion comes from the fact that the information regulator has recently published a guidance note on this issue to say, look, in thinking about this exemption issue, think about it along these lines. And what we've then tried to do, not only in an article on our website, but also just in terms of a session like today's one, is to break it down and try and make it a bit more digestible. But basically, the idea is that you fall into one of two groups when it comes to exemptions. And this is covered under Section 37 and 38 of POPIA. So you either have to apply for an exemption, or you are automatically exempt and you don't have to submit an application to the information regulator to apply. And one thing that I've done is to try and break it down into questions that you have to ask yourself in order to get a sense of where you stand. So maybe if I go into this slide and then just talk you through what the idea is with these questions. So one of the key things for me in thinking about exemptions, and this is something that I saw not only in the guidance note, but also in looking at, let's say, the Information Commissioner's Office, which is the information regulator equivalent in the UK. And I see actually some of the wording used in the guidance note comes from the Information Commissioner's Office website as well. And the idea is that you shouldn't try to be exempt just because protecting personal information is inconvenient for you. So one of the questions I asked then is, are you finding it very difficult or impossible to comply or implement one or all of the conditions? Because this is something for me, certainly, and I actually recently started preparing an application, an exemption application that we're going to submit to the information regulator. And one of the things I had to say in there is, we're not just applying because it's inconvenient to protect personal information. In certain instances, let's say, for example, the condition around notifying a data subject about your processing, that in certain instances, it's impossible to notify them. So that's some of the context there around the question. So the first question is, are you finding it very difficult or impossible to comply or implement one or all of the conditions? And then the other one, and again, the idea is if you answer yes to all of these questions, then likely your exemption application will succeed. It's not guaranteed, but the chances are quite good. Then, does your processing of personal information benefit your data subjects? So the idea here is that when you are applying to the regulator for an exemption, there are two grounds that you can rely on. The one is my processing benefits a data subject. Yes, my processing is not entirely in line with the conditions for lawful processing under POPIA, but you know what? I argue that my processing benefits a data subject more than it harms them. So that's the one ground. The other ground is then my processing, yes, again, it's not completely in line with the conditions for lawful processing, but it's in the public interest. It benefits the public, the wider public, not just a select group of people, but let's say a whole community, a whole city. It benefits that wide group of people more than it harms them, basically. So that's the first question is, does your processing of personal information benefit your data subjects? Does that benefit involve helping them obtain or exercise a right or get some monetary benefit? The information regulator doesn't give specific examples of the kind of benefits that they're talking about. So I tried to just think, and this is why earlier I spoke about how nonprofits, for example, could have an easier time answering yes to these questions, because if you're a nonprofit and you're giving bursaries to students who come from previously disadvantaged communities, you can imagine how that's a clear benefit to the data subject that probably overrides any bit of harm that comes to them when you don't comply with some of the conditions for lawful processing. And then the last question is, does the benefit substantially outweigh the harm that could come to that data subject due to you not complying with one of the conditions? And then in brackets, I say, if your processing only causes an inconvenience, for example, then your answer can be yes. So if it's just a slight bit of harm, it's the data subject getting an email that they don't want to get, and that's pretty much the extent of the harm that your processing does, then in this context, that's not really harm, or it's harm that can be overcome by the benefit that you're giving them. John, I don't know if you have any thoughts before I move on from this.
Yeah, for me, it's a classic scenario where we are balancing two things. And so on the one hand, you've got the public interest, other hand, you've got interfering with someone's privacy, and you weighing the two up and trying to decide whether the person should be exempt. So a classic example, the public interest is restoring the rule of law. And in doing so, you might infringe someone's privacy. But if it's more important to restore the rule of law, then you exempt. It's okay. And that's what we're doing here. The other one is that you're weighing up the benefit to the data subject versus the negative or harm to the data subject, and weighing up those two things. And a classic example here would be a pension fund wanting to find people who've not claimed their pensions. But the pension fund goes, well, I can't because POPIA stops me from finding those people. Clearly, there's a much greater benefit to the data subject than the possible infringement of their privacy. And possibly in that scenario, there's an exemption that could get granted. So I think that's for me, some examples and scenarios.
Yeah. And I think before I move on to talk about automatic exemptions, the other key thing, and this is quite important, and that is that the information regulator, yes, may grant your application, but the key thing is you might apply to be exempt from all the conditions. And if I flip across to the exemption form itself so that you can have a look at that, the exemption application form, you'll see that you have the option here of ticking. So this is where part A is basically where you're just giving some information around your organization, saying that it's a public body, a private body. But for the purposes of this discussion, what I really want to show you is part B. So you'll see here that you have the option in filling in this form of ticking and saying which condition you want to be exempt from. But the key thing is the information regulator, while you might want to be exempt from all the conditions, might say, hang on a minute, it's a bit of a leap to say you want to be exempt from implementing security measures, putting in good security measures to protect the personal information. So we will exempt you from having to comply or implement conditions 1 to 4, but you have to comply with conditions 5 to 8. And in addition to that, we're going to impose these additional requirements on you. So that's also something that the information regulator is empowered to do in terms of POPIA as far as exemptions are concerned. And then if I just keep scrolling further, you'll see, of course, that this is basically the section that calls on you, Part C, to then explain the ground that you're relying on. So let's say you've decided that public interest is the reason your processing is, you believe, in the public interest. So here you'd basically be able to select then that, okay, we believe our processing is in the interest of national security, is important as far as the economic and financial interest of a public body is concerned, or is related to research that we need to do about a particular virus that's affecting the country. And because of that, we need to do it, and we need to be exempt from certain conditions. But one thing in preparing the application that I referred to for a client of mine, I realized that there's not quite a lot of room here to explain the rationale for why you believe you should be exempt. So what I've done is basically give an overview, have an attachment, a letter that goes into a lot more detail about my application, and just reference that letter here as an attachment, as something that the regulator in evaluating the application should have a look at, in addition to anything else that I say here and anything else that I've ticked off or ticked in this form in completing it. And the same thing applies again when you believe that your processing has or results in a clear benefit to a data subject or a third party. You'd go through the same process of having to give a summary, and in my mind also refer to some other documents that are in support of your application, including this letter that I'm talking about that goes into a lot more detail about your application. And then you sign, and this part here is not really important for our purposes. And just quickly, this is what the guidance note, if you haven't had a look at it yet, this is what it looks like. But I'll just flip across.
Yeah, we've also, there's an article on our website where we've summarized that guidance note.
Yes.
And you can read that. To be honest, I don't think the regulator's guidance note really added much to what we already knew. It really is a summary of the law. We were hoping for more, but it's useful, but not as useful as we were hoping, because I think a lot of people have questions around this, and there is quite a lot of gray areas, and
yes,
we did want to try and get some more clarity, which wasn't forthcoming.
Yeah, I mean, there's quite a lot that is definitely still a bit uncertain. I'll also just flip across to this page here. So this is a sub-module in our data protection program. It's under this module here called Dealing with Regulatory Bodies, because ultimately all of this falls under the general concept or general requirement of having to deal with, in this case, the information regulator. That's why I mentioned prior authorizations at the beginning, although that's not something that we're particularly discussing during today's session. So if I just flip back across to the sub-module in the program and go back to the questions. So the other one now that we are talking about is organizations that are automatically exempt. And these are basically the questions that you'd have to ask yourself. And here, and this is quite important to give a sense, basically, of which organizations we're talking about. Picture here the Law Society. The Law Society is a body that is exercising power in terms of a particular law, and that power is to manage the behavior, the conduct of lawyers, right? And as part of, let's say, investigating the unethical conduct of a particular lawyer, the Law Society will have to investigate that lawyer. And you can imagine that if they have to inform that lawyer, maybe that the investigations have started, maybe the lawyer will destroy evidence. So that's why one of the conditions that you'd have, or requirements that you'd be exempt from if you fell into this category of bodies that are exercising power in terms of a particular law in order to protect the public from suffering harm and manage the conduct of particular people, particular professionals. That's why it makes sense to be exempt from certain conditions. Again, the exemption is limited. It relates to, for example, being exempt from having to notify data subjects about the processing. It relates to the further processing limitation in POPIA, where you're supposed to only process for the initial purpose and not come up with maybe other purposes for processing the personal information. And so these are basically the questions then that you'd have to ask. So, are you exercising power in terms of a particular law? Again, you don't necessarily have to be a public body. It's just that you have to be exercising power in terms of a particular law. Does exercising that power involve you regulating certain people to protect the public from harm? Again, this example, this analogy of the Law Society works, I think. And then just to help these questions make a bit more sense, I also then, because often with people, when you link it to something that they're familiar with, you draw that comparison, it makes a lot more sense to them. So are you similar to an industry body or ombudsman that regulates certain people? So if you've always thought of yourself as being very similar to an ombudsman, and the answer to the first two questions is also yes, then chances are the processing that you're doing, or so some of the processing that you're doing, is automatically exempt in terms of POPIA. But one thing that's also quite interesting, because we were talking, John and I, about just the various people that are going to be on this webinar. And one of the things that came up is, well, if you fall into the category of people that are automatically exempt, once you've figured out that, you know what, we are probably automatically exempt, shouldn't you just immediately drop off this webinar then and leave? Then a thought that I had is, well, you might be automatically exempt from some of your processing, but then there's the other processing, the rest of your processing, that you might very well want to apply for an exemption for. And so that's actually quite interesting. So you might find that some of you might wear two hats on this webinar. So I just want to, I'll just flip back across to the Prezi, and then just have a look at some of the polls that I could potentially run.
Just before we run well, actually, let's run the polls, because I think we've got a poll for whether or not you think you should apply, and then a poll for whether you're automatically exempt. So maybe let's start with the one on whether you could apply.
Yes, John, I think that's a very interesting poll too, because I think a lot of people are a little bit confused on whether or not they exempt, and then also when they think that they exempt, also what conditions are they exempt from? So that is like the trend of most of the questions. I think that's a good poll to run.
Should we start? Maybe, John, if you could select the poll that you have in mind, because there are quite a number of ones. For example, one poll that I wanted to run was just finding out why people want an exemption. So that's actually one that I didn't get around to running as well. So maybe if we start with the one you have in mind, or I can run this one first.
Let's run that one first. I think that's a good idea.
Okay, sure.
If people can be quick on the button, though, just in the interests of time, so that we're fast. And Sicelo, I see the sun is determined to spotlight you there on the.
Oh my goodness! Yes, yes. So let me just sort that out. Sorry about that. So yeah, I'll fix that.
Good to see you in the spotlight.
I hope that's better.
Yes, that is a bit better. Yeah.
Okay, yeah. Just quickly, in terms of these, just having a look now, again, this relates to what I was saying earlier about exemptions and you having a good reason why you want them and those different questions that you have to ask. So if I just end, haven't had many people vote, but I think let me just end it there and then just share the results quickly. So many people here believe that compliance is too expensive, but that certainly would be one of the considerations that would make you want an exemption. But for me, it's also just the other one that says it's impossible for us to comply with some of the conditions. Our processing benefits data subjects more. It benefits data subjects more than it harms them. So there are quite a good number of people that say that, of course, this was a multiple choice. So a number of these could apply to one organization. But John, maybe if you take us through to the one that you had in mind.
Okay, perfect. So the question really is around who should apply for exemptions, and I'm going to launch this poll. So the question is, do you want to apply to the regulator for an exemption based on what we've been talking about? And so remember, these ones are the scenario where the public interest outweighs an infringement of privacy, or the benefit to the data subject outweighs the harm to the data subject. And yeah, it's good to get an idea. I mean, so I think some of the questions are also about, well, I'm not sure. I don't know whether I should apply or not. One thought is that you've got nothing to lose by applying. The regulator can say no, but it's not like they're then going to penalize you. So I think if you're not sure and you want to be, and you think you've got an argument, it probably would be a good idea to apply and see if you can succeed. But let's end that poll there, and I'm just going to share the results. So most of you are saying no. And I think that is pretty much what we were expecting, in the sense that it's only a very small group of organizations that are exempt. Not many people are, and it's going to be quite difficult to prove some of those grounds.
Yeah.
And that application form it's quite daunting. There's a lot of information you have to give there. And so I think that's unfortunately the reality, that probably most of you shouldn't apply because you're not going to be exempt. Not the answer you wanted, but I'm afraid that's probably what it is. And then the second poll relates to whether you're automatically exempt. And let's launch that poll and have a look here. So is your organization automatically exempt from some sections because it protects the public? So a great example here would be the public protector. For me, I couldn't think of a better example. Their job is to protect the public. And so if they can't protect the public because of POPIA, then they should be exempt from POPIA. But there could be many others. And I think there is some people asking some questions, and I can see different scenarios. And private bodies, there might be many that do things that really do protect the public. And in that scenario, you might be automatically exempt. And the interesting thing here is that you don't need to apply for it. You're automatically exempt from certain sections. So you, as the responsible party, can determine which activities you believe you're automatically exempt and record that. And that's all you need to do. And then if someone challenges you, or the regulator investigates you at a point in time, you would say, no, we believe we were automatically exempt from POPIA or these particular sections for that activity, and therefore we didn't comply. But it's interesting to see the results here, and sharing those results, you'll see that 80% of you are saying no. And unfortunately, this is what we anticipated happening in this webinar, is that very few people would be exempt. And I started the session by making the joke and saying that there's a big crowd here today, because wouldn't it be lovely if most of us were exempt from POPIA and we didn't need to tackle it? And unfortunately, that's not the case. And the polls and this session is reflecting that.
Yeah, definitely. But I think what you said, John, about those that do think they're automatically exempt, them needing to record that, I think that's actually quite key. And in many ways, it applies to other aspects of POPIA as well, where it calls on you to interpret, to look at a particular section and come up with what you think is your interpretation or understanding. It's often quite helpful to record that so that people in the organization also have a uniform understanding, or at least the key decision makers or stakeholders have a uniform understanding of it. And then when you're challenged down the line, you can pull that out and say, well, hang on a minute, here was our reasoning and interpretation of that.
Perfect. Shall we go to some questions?
Yes, yeah, I think so. I mean, I'm sure there are quite a lot.
Yes,
Jade?
yes, there were a lot of questions, I think, related to what you're talking about. Someone asked that if they do cybersecurity that is to the benefit of the public, would some of the processing for those activities be exempt?
I mean, again, there are a number of considerations there. So the one is, as we said earlier, is it depends on whether the harm that comes from providing or doing that cybersecurity outweighs any potential benefit, and also how big the group is that this benefit is being extended to. So those are some of the considerations there as well.
I think it's interesting that you also mentioned that how big the group is that it benefits. That I think is definitely something to think about. And then there was another question about what about research and what types of research would allow for an exemption. It would also be for the benefit of the public, right? Or the data subject. Can you speak a bit about research?
Yeah, so basically, if you're applying and you're saying that your processing is in the public interest, one of the things you can rely on is, look, we aren't processing just because, I don't know, we want to, for the sake of it. We're processing because there's something, we're on a mission here. And that mission is and of course, this will sound quite, it relates to what's happening around the virus, right? And that is, okay, there's this virus that's on a rampage and someone needs to do research on this. It'll involve dealing with a lot of personal information. It'll involve taking the personal information of ordinary South Africans, doing medical tests and the like. And so we can't comply with all of the conditions. We can't give effect to all of them. Please exempt us for those reasons. Again, I'm not saying that health-related research is the only type of research that you'd be exempt for if you are processing personal information as part of it.
Yeah, maybe if I can add there, and Sitkala, maybe you can stop sharing your screen just so that the audience can see
yes.
us in our full. There we go. Yeah, I think when it comes to research, there's the term historical, statistical, and research purposes, but those purposes are not excluded, and they're not mentioned under the exemptions, but they are mentioned in various places in POPIA where the law isn't as strict on you if you are processing for research purposes. But certainly you're not excluded, and like journalistic purposes is excluded, research purposes is not excluded, and it's not exempt. And then the other thing that I wanted to add, and I see that Shirley, for example, said what constitutes the public interest. And what makes this a difficult topic is that the concepts are very vague and very open to interpretation. So you're comparing the public interest with an infringement of privacy. Both are pretty vague concepts. And the public interest, it changes and morphs over time as to what is in the public interest. And so it's a difficult thing to do. And I think that many of you might be feeling, well, I need more concrete examples. I need more specifics.
I mean, an
And,
example. Yeah, sorry, John, go ahead.
Yes,
Finish
go
your
for it.
thought. Okay, an example that I can think about where you're not necessarily a non-profit, so you're a for-profit company, but as part of some CSI initiative, you are sponsoring a non-profit that is dealing with certain communities. And in order for you to measure the effectiveness of that CSI initiative, you say to that nonprofit as part of the grant agreement, look, we want to be able to have a right to go and interview at random some of the data subjects, the beneficiaries that have supposedly benefited from this project. So you can see how that definitely has an impact on the public, and it's not a small sample size group. I mean, you're dealing with a number of communities here that are impacted by the processing. So for me, that is quite a workable analogy or example.
Great. So are there any other themes of questions that have come through?
Let me see. I think what is important, I think, for people to remember is that even if they are exempt, they won't be exempt on everything, because a lot of people were asking, like, do they need to appoint an information officer? Do they need to have a privacy policy or a POPIA manual? Like, those are not the things that are exempt. So I think it's just like good to, because people were asking questions about that. And then another question people were asking about, you know, when you fill out the form, if you go maybe to church or a restaurant or any business and you have to fill out the COVID forms, would that also fall under an exemption like this?
And in that case, are we talking about let's say the restaurant and let's say the owner of the restaurant, the company owning the restaurant, are we saying, are they exempt from having to comply with the conditions as part of the processing that they're doing there?
Yes.
Yeah, I mean, it's quite tricky, but you could maybe make a case that because ultimately you're doing it to benefit data subjects and because the benefit that those data subjects are getting maybe is more than the harm that they could potentially suffer, that for that reason, yes, you can get an exemption. But here's the question, or here's the issue I have with that. And that is, I've also, as a normal person, gone to various restaurants, and often there you're presented with some sort of physical register, and it even asks for your ID number. And of course, one of my arguments is, why do you need my ID number as part of this purpose of keeping a record of the people that have visited your premises? And is there not a way where maybe you could use a tablet and keep it electronic, where when one patron comes in, fills in their details, then other people who come after don't see that? So it's quite tricky to say that the restaurant should be exempt for that.
I think on that is also that you won't be exempt of the technical measures. So you still need to have measures in place to protect the data, even though you could still take those people's information. And then there was another question. Do you want to continue with questions? We have like 5 more minutes.
Yeah, I was just going to quickly comment on exactly what you said, because I think it's important, and I mentioned it earlier, and that is this idea that if we look at these conditions, some of them are easier to get an exemption for than others. Others, because of the impact that it could potentially have, the harm that it could potentially bring. Again, we harken back to this idea of harm. Because of the harm that it could potentially cause a data subject. I mean, think about these various conditions, the fact that if you don't secure the personal information, that versus you not informing a data subject or not collecting directly from them, you can see that the harm in the one far outweighs the harm that could befall a data subject because of you not complying with the other.
Thank you, Sikelo. I think that was very helpful and informative. There was another question that someone asked, because the topic of exemption is particularly very difficult to interpret, and even with the guidance, people are struggling to determine whether, especially if whether automatically exempt, should they obtain legal advice on this and some help on it, or would it be fine if they just do it on their own? How would they approach that?
Look, I think often with many of these issues, we all need as much help as we can get. So I wouldn't say it's necessarily a bad thing to get some legal help. Obviously, you can try and use the resources that are available at first, have a look at the guidance note, have a look at something like the article that we have on our website, and of course, a webinar like today's one, which was publicly available. And then if that still doesn't help, then naturally the next step is to then think about what help you can get. Of course, in our program, we're building this module, this sub-module, which is what I showed you earlier, and it will be doing a lot more work because there's quite a lot that came out of today that John and I were talking about, going back and forth. So there's quite a lot that we're going to be doing to build it out into the program. So something like our data protection program is worth looking at as well, in order to just find out some of our further thinking that we'll be coming up with after today's session.
Yes,
As part of, yes, sorry, John, go ahead.
Yeah, as Michalsons, we want to empower you to be able to do as much yourselves as possible. And that's exactly what the program achieves. So if you found today useful, you will find our program useful. But then there might still be questions, even though you work through the program, and there could well be questions. And then we can assist there, either in researching the law or developing your argument as to why you should be exempt. It's, actually filling in the application form and submitting that to the regulator. That's not the tricky bit. The tricky bit is formulating your argument as to why you should be exempt. And as we've discussed, they're tricky concepts, and we can certainly help you with that. I mean, concepts like the public interest or legitimate interests or the reasonable person or reasonably practicable, all those terms are just made for lawyers. We can argue for days about those sorts of concepts. But yeah, we're happy to help.
Yeah, definitely. I mean, when I was preparing the application for the client that I mentioned, I spent quite a bit of time thinking through these issues, researching different laws, trying to find different things that ultimately build or explain why the processing of this client is in the public interest. Because, I mean, as John said, and in fact, even the regulator acknowledges it when you read the guidance notes, that it's quite a difficult thing to pin down. And also when you look at the ICO's website as well, you also get that sense that it's difficult to define exactly what the public interest is. You can give examples like I did, but it's quite difficult to fully pin down.
Sade, are there any other questions or themes of questions that have come through? I can see and I'm always feel bad for the audience. We've got about 100 questions in total, and it's really difficult to get to everyone. So I'm really sorry if we're not getting to all of your questions. I think also we're ignoring questions that are of general application. We're really just looking here at exemptions. I will pop into the chat a link to a page on our website which has got FAQs, and there are probably 50 questions and answers there, which might well help you to answer some of the questions that are being raised.
So do you want to maybe do one more question?
Yes, I think so.
So there were a lot of questions, and like John said, sorry that we couldn't get to all of them, but I tried to answer some of the other things unrelated to exemption in the chat box. But here was one very earlier on from Megan. She said she wanted to ask about the scope of POPIA and exemptions in terms of legislation, such as the Legal Practice Act and the Audit Act. So more specifically, where it relates to correspondence involving privileged information. I think this is a very difficult one to maybe approach. And then will the exemption apply for all legal advice, and then also only to legally privileged matters? So she also apologized because she thinks that this question might not apply to everyone in the group, because this may be a little bit of, there's not a lot of people that does work like that that's on the webinar. So I don't know if you want to answer that.
John, do you have any thoughts in regards to that?
Yeah, I mean, that's a tricky one. I think that I mean, essentially, so you might be automatically exempt in that, are you protecting the public? And I think you probably can create an argument as to why you're protecting the public. So I do think that there's a possibility there. And then in terms of the application, yeah, I think you probably also public interest outweighing an interference of privacy or benefit to the public, the data subject. So I think that is a good example. I mean, one of the challenges we have at the moment is that nobody's been exempt. So the regulator has to publish any exemption that they grant in the Gazette, and none have been granted or none have been published. So we literally have no examples to go with. All we got is the law and the guidance note from the regulator, and then our interpretation or your interpretation. So this is going to be a developing area that gets crystallized and clarified over a period of time. So, you know, there are lots of great questions of practical examples of whether it be exempt or not. And really it's the only way we're going to work out is if you test it, because we don't have precedent to look at. We can't see more than what you're seeing. So I think if you're not sure, I would either rely on the automatic exemption until such time as the regulator tells you that you're not automatically exempt, or it would be to apply, or it would be to look at international jurisdictions and see what exemptions applied in other countries and build your argument in a South African context.
Yeah, I mean, the thought that I would add there is, certainly if you're going to, let's say, assume that you're automatically exempt, the one thing would be to document your reasoning. And of course, as John said, to build your argument, basically. And then the other thing is to just comply as far as possible, so to try and score some of the quick wins around protecting personal information, so that if you have wrongly assumed that you're automatically exempt, that there isn't too much harm that comes to a data subject, because some of the actions that you have taken to protect personal information have mitigated that harm. And when the information regulator, let's say you suffer a data breach, does come knocking on your door, then you are able to say, hey, look, first of all, we did have this sort of sound reasoning. And secondly, we did try and put some actions in place to mitigate any potential harm that could befall data subjects. And then the last thought is just that, yes, certainly some issues are a bit fuzzy. What does public interest mean? What does benefit to a data subject that outweighs the harm mean? But certainly from my side, I will be doing a lot of thinking about this. As I showed you, I am building the submodule in the program, and there probably will be other webinars that I'll do moving forward, maybe one for members of the program or maybe another public one. But I will be doing a lot of thinking around this, and there certainly are already clients that are pretty much in the process of applying, and I am helping those, or will be helping those. So I will be thinking about these issues quite a lot, and I will try as much as possible to build out this area of the law so that we get as many answers as possible, or even if it's just an interpretation, to make sure that it's a sound interpretation of the law.
I think maybe we should leave it there, or I have to go to another meeting. We could stay and answer more questions if you want, but otherwise I think we've been going for over an hour. Maybe we should leave it there.
Yeah, I think we can leave it there. Thanks a lot, everyone, for joining us. I mean, I love talking about data protection, and it was lovely that we had a full house. I feel like a legal rock star. Stella and the Michalsons.
That was
Thanks,
very,
everyone.
that was very good. And there's a lot of thanks going. Thank you, John, and thank you, Sicelo. They really loved this session.
Okay, awesome. Thanks, everyone. Cheers.
Bye.
Thank you. Bye.